for joining us today. Thanks everyone for joining us today. My name is Jeff Goldman, and I am an immigration lawyer in Massachusetts, based in Salem, just north of Boston. And my law firm has offices in Boston and Cambridge, Massachusetts, and also in the Silicon Valley in California. I'm really happy to be joined today by my colleagues Malvina Driscoll and Kaja Lohr. And the reason we wanted to have this webinar on Zoom today is because there's so many urgent things happening in the world of H-1B visas. There's some confusion, there's a lot of strategies, and information needs to be disseminated, and that's what we do every day. So I'm happy that we now have a chance to meet with all of you and give you our thoughts on the best way to handle, if you're an employer, you want to know how the best strategies for your foreign national talent. And if you're a foreign national, you want to know the strategies that are going to make your life in the US move smoothly, and how best to take advantage of all the different immigration strategies out there. So thanks everyone, and we will move forward.
Hi, everyone. My name is Malvina Driscoll. I've been an immigration attorney for roughly 20 years and with Jeff for 10 years. It's great to be here with all of you. I specialize in employment-based immigration, and our firm works on all kinds of non-immigrant and green card immigration options. So we are excited to be heading into H-1B season and look forward to giving you all the information you need to know about this year's lottery. And Kaja Lohr is also going to be working on telling us about this. I'm going to be starting off with talking about just the H-1b visa process in general and the lottery in particular, and we'll close out with some other alternatives aside from the H-1b cap. So the H-1b visa, just to give you a rough overview, is an excellent non-immigrant visa that's widely popular in the US because it's for professionals who have a bachelor's degree or higher in a specific area of study, and they want to be employed by a company in the US who has a job role that requires a bachelor's degree or higher in a specific area of study. It's a great visa because you can not only work in the US in non-immigrant status, but you can also pursue a green card simultaneously without it impacting your H-1B status in the US. The total amount of time you can generally get H-1B status is for 6 years total in increments of 3 years. But you can actually get more than 6 years of status if you have started the green card process and you might be on a waiting list due to your country of nationality. So there are times when you can get more than H-1B, more than 6 years of H-1B status. Spouses and minor children under the age of 21 can be with an H-1B worker in the US in H-4 status. And while generally H-4 spouses cannot work, if the H-1B holder is in a certain period of the green card process and they're stuck on a waiting list, in certain cases, the H-4 spouse can apply for a work authorization card from USCIS. So those are some of the benefits of the H-1B visa. It's important to understand some of the main criteria for the H-1B category, because it's not simply for someone who has a bachelor's degree to work in the United States. It's very important that the employer employing the H-1B worker is offering a role, and the H-1B worker is working in a role that requires at minimum a bachelor's degree or higher in a specific area of study. If you just have a general bachelor's degree that doesn't have a specific specialty, such as we see business administration a lot with no particular focus, that would be hard to show that you have the criteria of the qualifying education for an H-1B. And even if you have a bachelor's degree or higher in a specific area of study, but the employer is employing you in a role that would not normally require a bachelor's degree or higher, then that will also not qualify you for the H-1B status. So that's also very important. For the lottery coming up, and we'll get more into the various dates and times, you do need to show that you have at least the bachelor's or the master's degree by the June 30th timeframe, when the H-1B petition would have to be filed by the employer if you're selected in the lottery. So that's what we also look at when we're evaluating people's qualifications and their immigration status as they're preparing for the lottery. And also it's very important to understand that the employer must be paying the H-1B worker a fair wage or the prevailing wage for the occupation for the area where the person is going to be working. It's not just simply whatever the employer wants. There are minimum wage standards that are set by Department of Labor. And we research this as we're evaluating the job roles and people's qualifications to make sure that if the company is going to be offering a certain role, that they are paying the wage that's really required by the Department of Labor for that occupation. So the H-1B is terrific, but it's also, there are only so many given per fiscal year by the U.S. Immigration Service. If you're selected in the annual cap, then you do not have to go through this every year. But this is really for people who've never been in H-1B status, or you're coming to work from abroad and you're applying for an H-1B visa. There are only 85,000 H-1Bs that are offered by the U.S. government each year, 65,000 for those who have a bachelor's degree or higher, and 20,000 for those who have a U.S. master's degree or higher. Last year in 2021, over 300,000 people applied for the lottery. So knowing that there are far more people that want the 85,000 than that they have available, that's why the USCIS is required by law to conduct a lottery for this. So some things to think about as you're considering whether to enter the lottery or trying to look into an H-1B is certainly you want to make sure that your degree, your education is specialized in a specific area so that you can link that specialty to the job role that the company is offering you. And it's also important to understand that even if you don't have a U.S. bachelor's degree, some foreign education can be the equivalent of a U.S. bachelor's degree. And even if you have some qualifying education that may not be a U.S. bachelor's degree, you can combine that with professional work experience. In addition, it's also good to know that you can be sponsored for a part-time H-1B role. It does not have to be a full-time H-1B role. So there's some flexibility there. So the lottery. It's very important. It's coming up. It's generally every March, and this is going to go into some of the actual heart of going about the lottery, how it's done, and how to register. So it's important to know that employers or U.S. companies are the ones who submit the lottery registrations to USCIS. USCIS has an electronic platform, and the employers or the U.S. companies who are submitting the registration may create an account on this platform, and they submit electronic registrations to USCIS. In fact, in the chat room, I'll see if I can type in later on the exact website to go to where companies can create this account. So employers can start exploring this USCIS website, but February 21st is a critical date because February 21st is the first date that the employer can create what's called an H-1B registrant account. The employer at this point is not submitting an H-1B petition. The employer is only submitting an electronic registration to USCIS so that USCIS then conducts the lottery from those electronic registrations that are submitted to them. So on February 21st is when a US company, and this US company doesn't even have to be the person who's employing the person right now. It could be any US employer, but it does have to be a US company. On February 21st, they can start creating their H-1B registrant account. And in that time, the company is putting in pertinent information about them, about the company, their name, their address, their federal employer ID number, the contact person, and the person who will sign the registration electronically when it's submitted. For actually submitting the registrations to the lottery, that begins on March 1st at noon Eastern, and it goes until March 18th, which is a Friday, till noon Eastern time. So in that period of time, anytime during that period, the company can submit the electronic registration to USCIS. There is no benefit to submitting the registration on the 1st or the 2nd. Submitting the registration earlier does not give you any greater chance at being successful in the lottery. It can be done anytime during that period. In fact, sometimes I wait a day just to make sure that the USCIS platform doesn't crash, that they're not having technical problems. But it's certainly fine to submit the registration anytime during that period. Certainly, it's best not to wait until the 17th or 18th because the platform slows down, more people are trying to get onto it, and there could be glitches or it could freeze up. But anytime during that time is fine. An employer can also create an account, an H-1B registrant account, anytime during that period as well. It doesn't have to be done only on the 21st of February. The 21st of February is only when it begins, and the employer can create their new account and submit that registration. Some of the basic information that the company will submit in the registration is obviously the information about their own company, and about the foreign national. They require name, date of birth, country of nationality, passport number, and also which cap that the company is submitting the registration for. The 65,000 H-1Bs that are available are for what's called the regular cap. It's for H-1Bs that require well, all H-1Bs require bachelor's or higher, but the regular cap is for those individuals who have a bachelor's degree or higher, whether it's a US bachelor's degree, a foreign bachelor's degree, or a combination of the two. The 20,000 extras that are allotted for those who have a US master's degree or higher. That is called the master's cap. So when the company is submitting the registration, they do have to designate which cap they are selecting for the registration. And so up until this time, as employers are getting ready and we're helping employers, we're helping foreign nationals explore the lottery and whether they qualify, we're looking at all of these things. We're looking at the job role, we're looking at the education, and we're looking at the strategy of whether you're going to apply for the regular cap or the master's cap. The advantage of the master's cap is that you essentially get 2 bites at the apple. If you're not selected in the lottery for the 65,000 H-1Bs, those who have a US master's cap will be thrown into the second pool where they're selected for the additional 20,000. So it is certainly more advantageous to have a US master's degree. But at the same time, you must make sure that you have that master's degree by the time the H-1B is filed with USCIS. So when the lottery registration period closes on March 18th at noon Eastern time, that is when USCIS will take all of that information, all of the registrations, and conduct the lottery. During that time, they're going through the data. They're also making sure that no duplicate registrations are filed. One company can file multiple registrations for multiple foreign nationals, but if you are a foreign national, you cannot have that company file more than one registration, or it will be considered a duplicate and all of them will be thrown out. So it's important to be in communication with the company that's filing the registration to make sure that they don't submit more than one. Otherwise, they're duplicates and they are thrown out. But again, a foreign national can have 5 companies submit a registration for them, but one company can file multiple registrations for different foreign nationals. But for one foreign national to one company, that's the only registration that can be submitted, no duplicates. The lottery is conducted electronically. We have seen in the last couple of years when the lottery registration closes, USCIS generally starts sending out notifications within maybe 2 to 3 or 4 days, fairly soon after the registration period closes. You will not receive an email that you have been selected. The company will receive an email from USCIS stating my USCIS account has been updated. And essentially, it's a trigger for them to check their My USCIS account. When the company goes into their account, then they will see which lottery registration has been selected. But the foreign national will not receive an email specifically yes or no. And in addition, when the company goes into the account, they will not see whether someone has not been selected. It simply says submitted if they have not been selected. They are certainly notified if someone has been selected. And there's an important reason for those unselected registrations to stay in the system with USCIS. And so that's how they are informed by USCIS that the lottery has been done and that employers are notified. And so I will pass it on now to Kaja Lohr to go on to the rest of the lottery and H-1B submission process.
Thank you, Malvina. Thank you, everyone. Just a quick introduction. I'm also a partner at Goldman & Partners, and I actually applied for the H-1B lottery years ago myself. I wasn't selected, that lottery system looked so much different than the current one, which I'm actually glad that they changed it to this electronic system. It's so much more efficient. And the registration periods and submitting all the registrations and then being notified about all the selected cases takes us to the next step that requires the companies that for cases that were actually selected in the electronic lottery to proceed with submitting all the required H-1B forms, support letter, and supporting documents, including educational credentials, including information about the company, evidence of non-immigrant status, if applicable, for a person who the companies are filing for. So all this paperwork has to be filed within 90 days from April 1st, at least for the initial round of the H-1B lottery. So our deadline to submit the paperwork for those who were selected is June 30th. You also have to be aware that because the beginning of the federal government fiscal year is October 1st, once the paperwork for the H-1B is submitted and the Immigration Service then adjudicates it and approves it, the start date of the approved H-1B will, the soonest it can be, it's October 1st, 2022. What is also very, I think, I mentioned that this lottery is so much more efficient is that because of the fact that the lottery happens electronically and they have a better way of tracking the numbers that they're actually using, the H-1B numbers they're actually using. The Immigration Service now has the ability and has done it for the last 2 years that they, once they realize that some of the H-1B numbers are not used because, for example, a company decided not to file the paperwork after the cases were selected, or maybe some of the H-1B petitions were denied after they were submitted or withdrawn later on for various reasons. All these unused numbers are then collected, and then as a second round of the lottery can be conducted. Typically, it happens around August, and then additional cases are selected. And in 2021, the USCIS surprised us and ran a third round of the lottery in November. So every time the round of the lottery is completed, they give you the 90-day period from the moment the cases are selected to submit the paperwork. So the important thing to keep in mind is that if you do not get a notification that you were selected by April 1st, do not give up, because you may still be selected later on during that year. A few tips about, I think Malvina mentioned the US master part, that really any degree that you want to use to qualify for the H-1B, the Immigration Service is going to be evaluating whether you qualify based on the time when the petition is submitted. So if you are submitting a registration in March, you don't necessarily have to have either bachelor's completed or US master's completed, but if you know that by June 30th, you will have the diploma that is required, you're still eligible to submit the electronic registration in March. One of the tips here mentions that you don't have to use master's to qualify for specialty occupation. What this really means is that if you hold a US master's or higher, you will be qualified for the US Master's Cup lottery, even if the job that is being offered to you by the company does require only a bachelor's degree as a minimum requirement. So it's really, the US Master does not have to be required by the job. Just by the virtue of you having such a degree, you qualify for the US Master as a foreign national. We typically recommend, because the timeline of the lottery is that even though you can submit paperwork starting April, between April and June, most of these cases should be approved by October, but many of them are approved, let's say, by the summer. There is still a period of time when you are in kind of transition period, depending on what is your original non-immigrant status. We'll talk about it later. There are different things that you can do to ensure that you can stay here if you're in the United States during that transition period. But if you are an F1 student, which is the most common scenario, and you got selected and approved, let's say in July for the H-1B, our recommendation, general recommendation, is if you can avoid traveling between really filing the H-1B, and then October 1st, when the H-1B starts, that's the easiest way to transition. And of course, if there are emergencies, we can talk about it, we can discuss it, but generally be prepared not to travel if you don't have to. I think that's all. We talked about the different lotteries already, so I think we can go to the next slide, Malvina, if you don't mind. So as I mentioned, the most common scenario for people to enter the H-1B lotteries for F1 students who graduate from US universities, and then typically they start working for a US company on their optional practical training, which is a work authorization that F1 students are eligible for after graduation. The OPT is really a 12-month period of work authorization, and certain people that graduated in STEM fields are also eligible under certain conditions for additional 24 months of this OPT. We call it STEM OPT. And I want to give you kind of quick overview of the main characteristics of these two types of work authorizations, because there are some differences, which I hope will be helpful for people on this call. If you are on OPT, what you need to know is that you can consider being a volunteer while you're on OPT. You have a certain amount of unemployment that you're allowed to have in the OPT status without violating F1 status. You can work very part-time. You can, of course, work full-time, but part-time work without a specific minimum number of hours is allowed in OPT. And the main criterion is that the OPT, the work authorization, allows you to work in a position that is related to your field of study. So if you graduated, for example, in computer science, you will be eligible to work in your OPT as a software engineer, for example. And the STEM OPT for those who graduated with STEM degrees has some differences that you should be aware of. Generally, first of all, the difference is that you have to have an employer who is willing to submit an I-903 training plan. It's a document that the US company that wants to employ you in STEM OPT needs to complete. You and the company representatives need to sign it. And then that I-903 needs to be submitted to a designated school officer for review and issuance of a new I-20, with which a foreign student can then submit a STEM OPT application using form I-765, with the Immigration Service. We didn't put it on the slide, but the US company can only employ a STEM OPT students if that company is enrolled in E-Verify. So that's another thing to consider when you're talking to if you're a foreign student talking to your employer, whether they're employed in E-Verify. Your job has to be related to your field of study, which is the same thing like in OPT. The difference is that there's a minimum number of hours that you are required to work in STEM OPT, which is 20 hours a week. You do have additional 60 days of unemployment allowed on top of the 90 days from the OPT. In terms of the payment, so the regulations really say that it's not that you necessarily have to be paid, but you have to be paid what typically people in this similar occupations are paid. If it is common that for the type of occupation you're doing, people volunteer, you may be fine volunteering in STEM OPT, but it has to be proven, and you should be able to prove that it's typical for the type of work that you do that people don't get paid. And it's, of course, very important that you file for the STEM OPT before your OPT expires, the initial 12 months, because if you miss that deadline, you're losing that potential of 2 more years of work authorization. This introduction, hopefully, it's going to allow you to understand how the transition happens, hopefully, after you get selected and you move to the H-1B status. One more tip before we move to the next slide. If you are a student who's thinking about opening your own company, you should know that under certain conditions, you may be able to get STEM OPT from your own company, as long as there is a certain way you set up the business, that there is employer-employee relationship, that there is some kind of outside board or someone who can be listed in the training plan as a person who will be supervising, who will be providing the training, who will be mentoring you through the STEM OPT period. So again, it's not not every company can do it, but in certain circumstances, and our firm has been successful setting it up for our clients in the past. I think we're ready for the next slide. So that, keeping in mind that many students, after they graduate, they hold the OPT or the STEM OPT while they're trying to switch to the H-1B. What happens if you have an OPT or a STEM OPT work permit that expires during that transition period between the time when you submit the paperwork, let's say it's April and October 1st. So that period of transition is covered, can be covered typically by a cap gap regulations. The cap gap allows foreign students to extend their work authorization automatically by the virtue of, first of all, being selected in the lottery and filing the H-1B petition. Once the paperwork is submitted and a receipt notice is received by the company, a foreign student can then take that receipt notice and go to his or her DSO and obtain a new I-20, extending their either OPT or STEM OPT until June 1st. That's the kind of interim extension. And then once, and I'm sure I got confused. Once we can, the extension until June 1st is based on the confirmation that the petition was submitted. So if you have a FedEx tracking number that you submit showing that the immigration received it, you could get it an I-20 valid until June 1st. But typically with the receipt notice, when a student presents it to a DSO, they can get an I-20 showing an extension, the cap gap extension until September 30th. You have to be aware that in order to get this cap gap extension, at the moment your company or the company that is sponsoring foreign nationals submits the paperwork, the work permit, the employment authorization document, whether it's an OPT or STEM OPT, needs to be valid on the date when the immigration receives the filing. Only then a person like that could be eligible for the cap gap. If the paperwork that the US company submits to the USCIS gets denied, the petition is not approved or it's withdrawn, that automatic cap gap extension is going to end immediately as well. I think this is all for the cap gap.
Thank you, Kaja.
Okay, great.
Thank you.
There are a couple of excellent questions that have been posted on the chat. And before we move on, I want to just answer two of the questions. Sena is asking, what happens if an applicant is chosen in the H-1B lottery, but the applicant, the employee, decides to move to another company and start a new job? Can that new company sponsor the person for H-1B? Actually, this is somewhat common, and we see one or two or three of these every single year. So here's what we can tell you. Winning the lottery for a very particular employer basically means you need to stick with that employer until October 1, when the new fiscal year starts, and you are actually in H-1B status with the employer who sponsored you. And then you can jump to a new company. Then a new company can file a petition for you. The danger of what would happen if you win the lottery and your employer is working on an H-1B petition, and you say, you know what, I'm going to go to company B. I'm not going to work for you. And company B is going to file an H-1B petition. And they know it won't be effective until October 1. The problem is if company A then withdraws the H-1B, they never filed the H-1B petition, or they withdraw the lottery success, you're done. You didn't win the lottery. Even though your name was selected, it's treated as if you didn't win at all. So that's really important to understand. Emmanuel asked a good question. How much does it cost to apply for the lottery? The government charges a $10 fee to enter the lottery. It's a very low bar. And that means lots and lots of employers are entering the lottery for employees. There are some law firms charge legal fees as well to help people enter the lottery. I'll tell you what our firm does. We charge a flat fee for the entire H-1B. Our flat legal fee is $5,500. If you want our help entering the lottery, we charge $1,000 to help not only to enter you in the lottery, but to thoroughly vet out the H-1B, to vet out make sure that all the documents are in place that will be needed if you win the lottery, to make sure that you have a good strategy and a good plan for filing an H-1B petition if you win the lottery. And for that, we charge $1,000 plus the $10 filing fee for the lottery. If you win the lottery, we only charge the remaining $4,500 instead of $5,500 because you've already paid us the first payment. Arnesh is asking, if you switch jobs, you have to enter the lottery process again if you already have an H-1B. Again, if this is after October 1, you've won the lottery and you are inside the United States in H-1B status, you do not need to win the lottery again. And you can go from employer to employer to employer. However, each employer needs to file its own H-1B petition because the employer needs to prove that their job is a specialty occupation, that they are paying you the fair wage. So that's why each employer has to file a new petition. But it is, you don't need to win the lottery again and again. Because Shiraz has asked the question, I'm not sure this is relevant to everyone, but if I get married to a person from my home country after winning the H-1B visa, is it complex to get her on board? I think it's actually a good question of where does a spouse fit into all of this? Really good question. So let's talk about that. If you're already married and you enter the H-1B lottery and you win the H-1B lottery, when the employer goes to file the H-1B petition, your spouse can put in the same file an application to change status to H-4. So let's assume you're F1 and your spouse is F2. At the same moment, the employer is changing status to H-1B. Your status, you can submit an application for a spouse to change to H-4. You could also wait to make sure that the H-1B is approved and then submit the application to change to H-4. That's what I think I would recommend, because why would you spend the money on the legal fees and government filing fees to ask to change to H-4 if you're not sure yet the H-1B is going to be approved? I think Shiraz is asking, though, what if you get married after you become H-1B? If your spouse is legally in the US in a non-immigrant status, it could be as a visitor, it could be as a student, it could be as a working visa classification, but they want to change their status here. And if they're in a legal non-immigrant status, they can file a change of status here to become an H-4, which is the spouse of an H-1B. If the person is abroad and you are H-1B, but your spouse is abroad, your spouse can go online and make an appointment at the US consulate in his or her home country to ask for an H-4 spousal visa. And the spouse would bring to that visa appointment proof that he or she is married, a marriage certificate, and proof that the spouse is in the US validly working in H-1B status. And then that person should be granted an H-4 visa to come. So more questions, we'll get to them later, but I do want to jump over to H-1B alternatives, non-immigrant visas that might work for you and to be considering from the beginning or after if you don't win the H-1B lottery. Briefly, an L1 is for a multinational executive or manager who's employed for a multinational company, meaning there is a company inside the US and a company outside the US, and they have a qualifying relationship. Usually one owns a majority of the other, or they could both be owned by the same group of people. That would be a multinational company, and executives and managers who have worked for at least 1 year outside the US for the multinational company could transfer to work inside the US for the multinational company. Many people who are foreign students or who are trying the H-1B lottery and lose really should know that they might be able to set up a very good L1 visa if they go abroad for 1 year and work for a multinational company. It could be a family-owned company. I urge you, meet with an immigration lawyer before you go, because there's so much you need to do during the 1 year you're working abroad, so much important evidence that needs to be gathered that you certainly want to know from the beginning to have a solid plan of the information you're gathering. Lastly, on L1, it's not just for executives and managers. It could be also for persons who have either specialized or advanced knowledge about either the field in which the multinational company is working or on the product or service that the multinational company is engaged in. That is also a valid reason to be transferred from abroad to the US on L1 status. TNs are only for Mexican and Canadian citizens. It permits them to work in the United States in a limited number of occupational classifications, and most of them are in the science, technology, engineering, and math fields. But if you're a Mexican or Canadian citizen, you are eligible for a TN to work in the US. E1 and E2 are the product of treaties that many countries around the world have with the United States for either a treaty for trade or a treaty for investment. Most of the countries who have these treaties are the typical suspects, the ones that we are the most friendly with, our closest allies. They're the ones that have the E1 and E2 treaties. But it does permit you to come to the US to work for a US entity that is at least 50% owned by a national of one of those countries. And here's one of the cool things. It works very well for startup companies. So if you are entering the H-1B lottery, you don't win, but you are from one of these treaty companies. I'll just throw one out, Japan. If you are from Japan and you have a startup idea, if your startup is receiving a substantial investment, and if a lot of that invested money is put at risk, and your US entity is 50% owned by Japanese citizens, maybe you, then this US entity can sponsor you for an E2 visa. So you don't want to ignore that opportunity if you're from one of the countries. You can Google E1, E2 treaty countries. You'll come up to the State Department's official list. F1 students with or without CPT. Sometimes going back to school is the answer. It might be the only solution you have. So people do go back to school to get another degree, and they think they try to work on CPT, which is curricular practical training. Most of these people are looking for the few schools out there that do offer day one CPT, meaning you can enroll to get a master's degree and spend your first year working off campus. It gives you a lot of breathing room, and to figure out your next plan. It gives you another year to enter the H-1B lottery. I will say that there's a lot of fraud that goes on with day one CPT schools. The Immigration Service is on it. They're investigating. So make sure if you're doing this, it's with a legitimate school that really does grant degrees and really does require people to finish their academic studies after they finish their CPT. O1 is for individuals with extraordinary ability, people who have risen to be among the top of their field, either nationally or international. The US Immigration Service lists 8 criteria that they will consider to determine whether or not you are extraordinary. And if you can provide evidence showing you meet 3 of the 8, you will be considered extraordinary. On our website, all over the internet are the 8 criteria. And if you think you qualify, you definitely want to investigate an O1. Can we go to the next slide? B1 or ESTA. B1 is a visitor visa. ESTA is the ability to enter the US as a visitor without any visa at all. That is reserved for about 30 to 40 to 50 countries. Again, countries with whom the US is closely allied with. There are certain activities you can do in the US while you're here as a visitor. You can consult with business associates, attend educational programming, business conventions, conferences, brainstorming sessions, inquiries about opportunities, negotiating a contract, and even a short-term training. A B1 in lieu of an H-1B is authorized by the US State Department for people who, in an urgent situation, need to enter the US on a B1 visa and work. This is reserved only for very few occasions. It's only for people who qualify for H-1B, but can't get an H-1B because there are no H-1Bs, and they need to enter on a visitor visa to work. The last one we had that was successful was a company who had a senior engineer who was due to go out on maternity leave, but she suddenly needed to leave 3 months earlier, like right away, needed to go into bed rest. The company was in shock. They were going to lose contracts and money. They had the perfect engineer abroad who qualified for this job, and we had them get a B1 in lieu of H-1B visa because it was for a short-term period and it was truly an emergent circumstance. The J1 is for a host of different programs run, authorized by the US State Department for cultural exchange. One of the programs is the Internship program, where if you are enrolled in an academic program at a foreign university, or you're within 1 year of graduating, you can come do an internship for 12 months. The J1 trainee program permits people who have at least a degree, at least a bachelor's degree from a foreign university, to come for 18 months of training inside the US. I will say that ever since COVID, it is very difficult to get a visa appointment for a J1. Unless you're coming as a J1 student, which is another one of the J1 programs. But for work opportunities, which are the internship and trainee J1s, very difficult to get a visa, and you definitely want to talk to an immigration lawyer before you head too far down that road. Next slide, please. I want to take a minute to talk about cap-exempt H-1Bs. By now you understand that there's a limited number of H-1Bs, 85,000 every fiscal year. That's called the cap. But Congress declared that there are 4 organizations who are exempt from the cap. They can always file an H-1B. The 4 organizations are universities, nonprofits affiliated with universities, nonprofit research organizations, and government research organizations. So if you're a foreign national and you are stuck, good to know, you're stuck because you lost the lottery, you're running out of OPT, you got nowhere to go, you might want to look to see if you can get a job with one of those 4 organizations, because you know they could file an H-1B immediately for you without winning the lottery. And that's true any time of the year. Well, there is a little known benefit to private companies who are not one of those 4 cap-exempt organizations. And there's a way for private companies to also benefit. And it's done through partnering with one of those 4 cap-exempt organizations. I want to give an example of this by using a nonprofit organization called Open Avenues Foundation. And I am one of the co-founders of Open Avenues Foundation, and we started it specifically to try to help foreign talent who is out of luck, didn't win the H-1B lottery, has to leave, and they have an employer here who's desperate to keep them, and there's no other alternatives. Here's how it would work. Because Open Avenues Foundation is a nonprofit affiliated with universities, it has about 6 or 7 or 8 contracts with different universities in the United States, and they are a nonprofit affiliated with universities. They are a cap-exempt organization. They can hire a foreign national part-time, because H-1Bs can be for part-time, maybe for 5 hours a week. And they would hire the foreign national to work as a global talent fellow who will lead an experiential learning opportunity for college students who don't normally get opportunities to have experiential learning. A good example would be community college students, maybe community college students enrolled in an associate's degree for an engineering kind of a background. They really would love an internship, some kind of experience with a company, so they can understand what is it really like to work on a project at one of these companies. We will take a mechanical engineer, a software engineer, we'll put them to work for 5 hours a week, leading an experiential learning opportunity, and we can get them a CAP-exempt H-1B for 5 hours a week to work for the CAP-exempt organization, Open Avenues Foundation. Here's the secret sauce. As soon as a foreign national is inside the United States in any H-1B status, whether it's been counted against the lottery, it won the lottery, or it's a CAP-exempt H-1B, any company may immediately file its own concurrent H-1B petition to employ the same foreign national in H-1B status. So let's just say there's an engineering company who wants to hire Miguel. Miguel lost the lottery. Miguel is out of OPT. Miguel has to leave the United States next month because he's already finished his OPT. He's in a 60-day grace period. He's going. He's got to go. His employer arranges with Open Avenues Foundation to immediately file a CAP-exempt H-1B petition for Miguel. The petition's approved. Miguel has never left the US because that petition was filed during Miguel's 60-day grace period. Miguel now is in H-1B status. The very next day, the engineering company files a concurrent full-time H-1B petition for Miguel. And now Miguel is working full-time for his company and 5 hours a week for Open Avenues Foundation concurrently. And everything is working out really well. Important points. Miguel must continue to work for Open Avenues for the 5 hours a week, because if he stops, USCIS will revoke the approved CAP-exempt H-1B that the engineering company was able to obtain. How long does Miguel need to keep going on the 5 hours a week? Until he no longer needs CAP-exempt H-1B. Maybe Miguel's company enters the next lottery and wins. Now on October 1st of that year, Miguel's CAP H-1B that won the lottery goes into effect. He no longer needs CAP-exempt H-1B status. He can stop working the 5 hours a week for Open Avenues. Open Avenues, of course, is not the only CAP-exempt organization that can do this. University of Massachusetts at Boston runs a similar program. I think the problem with their program is they're limited to 10 to 15 a year that they are doing. Open Avenues Foundation in 2021 had somewhere between 35 and 40 approvals, consecutive approvals of CAP-exempt H-1Bs, all of them without a request for evidence, all approved immediately. And every single one of those companies who filed their own concurrent full-time CAP-exempt H-1B, those were approved as well. If anyone's interested in more about that, I am happy to take a phone call. Danielle, who is hosting us today and moderating this event, she is the executive director of Open Avenues Foundation, and she is always happy to answer questions as well. I think we want to wrap up by taking any questions you all have, and I'm going to ask Kaja and Malvina, please post your questions in the chat. And I think Kaja and Malvina have been looking at some of your questions while I've been talking. So why don't you two take it over and bring up some of the more important questions that everyone can benefit from.
I have one question here. I'm sorry.
No, go ahead.
Just so we haven't answered Rohan's question about being an applicant for F1 student visa for this coming fall, 2022, and then trying to get an H-1B visa for 2023. So first of all, Rohan, you will have to have at least a bachelor's degree at the time you're filing for the H-1B. So if you are trying to enroll in a master's or PhD program, and then try the lottery in 2023, but then once you are selected in the H-1B lottery in 2023, you will have to make a decision whether you want to continue with your current program or whether you want to start working at that time. So it does not really trying to go these two routes at the same time doesn't necessarily impact the visas. It's just you will have to choose one over the other. You won't be able to be F1 and H-1B at the same time. Having said that, if you are an H-1B, a full-time worker, you are allowed to go to school at least, I think it's part-time, but as long as the primary purpose of your stay is working and you're complying with all the H-1B requirements, you may be able to do some kind of studying in the US. Depending on the program, you will have to talk to schools how they will treat that, but keep that in mind.
Great. So Arnesh had a good question about switching jobs and H-1B status. Can you start working for the new employer while the H-1B is being processed? So this has to do with someone who's been selected in the lottery. You've been in H-1B status because the company filed an H-1B petition, and you now want to work for a new company. It's called the change of employer H-1B. When the new company files the H-1B petition for you, upon the filing and receipt of that petition by USCIS, ideally once USCIS has issued a receipt notice, but it can be as little as showing that the petition has been delivered by either FedEx or DHL or UPS, you can start working for that company in H-1B status, and you do not have to wait for the second company's H-1B to be approved first. It's called H-1B portability, and the filing of the new company's petition alone allows you to start working, and you can do that while it's in process. And I believe Emmanuel also asked for a potential employee in the US who's not in the US. Can the law firm help them? Of course we can. If you're not in the US, a US company can still file an H-1B registration for you, and we can assist with assessing what's the job role, what's your education status, would it be a good match for H-1B, for the H-1B lottery and an eventual H-1B petition, and we can certainly help the company complete the registration process and monitor that also after the lottery has been done for future lotteries that year. So we can certainly do that for you.
Hey, Dong is asking a great question. He says he's currently an F1 student graduating in 2 years. He wonders if he enters the H-1B lottery and wins, does he have to become H-1B on October 1st, or could he put that off until after he finishes his F1 studies and maybe even after he finishes all of the OPT? The answer is yes, you can do that. There's two ways. The application form basically has a section where you have an option. Option A is, please approve the H-1B petition and automatically change my status to H-1B on October 1st. Right below it is a different box you can check. Please approve my H-1B petition, but don't automatically change my status on October 1st, but rather, please notify the US consulate in my home country, and I will choose when I want to go get an H-1B visa and return to the US in H-1B status. And then you might do it right after you finish your course of study before OPT, or you might want to do it after you finish OPT. You get the choice, but you don't lose that winning lottery number. So that's the answer to Hedong's question.
There's a question about a spouse on H-4 and a work authorization for such a spouse, whether the spouse would be, the H-4 spouse would be qualified for work authorization without the H-1B holder being on a track to green card. The answer is no. Unfortunately, the H-4 work permit is only available in those limited instances when the H-1B holder is at certain stages of the green card process. And then the question was, if we are on a different visa now, does the visa status change occur on the 1st of October? I think Jeff kind of responded to that. It may, if you select in the petition that you want the status to change automatically on October 1st, or potentially after, if the petition is approved after October 1st, or you can decide that you want to decide yourself when you want to activate that new status by asking for consular processing. The downside of the consular processing is that you don't know how quickly you can get a visa appointment and get a new visa stamp, depending on which country you have to go to do that. So that's something that you also have to consider before making a decision to apply for consular processing.
Nalvina, real quickly, can you go to the next slide while we're talking so that people can see how to contact us? Because some people are asking.
Exactly. You can email any of us, and we will be happy to set up a call if you want to do a consultation or ask about some more detailed situation.
Yes, absolutely. Great. Thank you, Joe. Kelsey had a great question of whether there are any concerns of traveling in F1 status before the H-1B petition is filed. For example, during March when the lottery is going on, even though the petition will be filed in May or June if you get selected. And there should not be any problem traveling before the H-1B petition is filed, because at that stage, it's only the registration that has been submitted to the lottery. The H-1B petition has not been filed yet. Once you correctly note, once you file the H-1B petition, or once the company does, then you definitely must be careful, and you really have to discuss, with an attorney beforehand whether it is safe to travel. Most of the time, if you're in OPT or STEM OPT and your H-1B petition has been filed for a change of status, by traveling abroad while that petition is pending, the H-1B petition can still be processed, but it will void the request for a change of status, so that it will require you to wait till the petition is approved, and then you would have to apply for the H-1B visa before returning to the US. But until that H-1B is filed, it should not be a problem to travel in F1 status, so long as you have valid status, a valid F1 visa, or if on OPT or STEM OPT, your work authorization card is still valid.
There's a question if we can help a company that needs 10 foreign workers. Of course, that's not an issue. That's what the company needs. We can go ahead and review all of that. And then there's I think important question: if a person owns a company in the US and it's a foreign national, can that person hire herself or himself as L1 and H1B? So for H1B, this is important to know, there has to be an employer-employee relationship between the company and a foreign national, which means that if you are a foreign national that has some ownership of the company, there has to be a way to set up your company that shows that there's maybe the foreign national is just one of the 3 directors on the board, and the board can only act with the can make decisions based on the majority vote of at least 2 out of 3 directors. We set up the company like that, even though a foreign national may be even majority owner. We have been successful in the past arguing that there is that control and employer-employee relationship. For L1 visas, the employer-employee relationship is not as required, as important as for H1B, so that could be possible.
One person is asking if there's a minimum amount of capital that is needed to apply for the H-1B. Well, the company has to agree to pay the fair wage, and the US CIS officer will want to see that the company has the means to pay the fair wage, but there's no specific documents that they're looking for. They really just need to see enough to give them the credit, to see the credibility that the company will be able to pay. So we try to put in financials, especially if they look good, contracts for work to show that money will be coming in, venture capital funding or letters of intent for funding about to come soon. And if there is truly a concern about whether the company can afford to pay the fair wage, it might be possible for the employer to file for a part-time H-1B, because then the fair wage is less. And that could be a strategic way to make sure that US CIS will be comfortable that the fair wage will be paid.
There's a question whether a recently established company can sponsor an H-1B. The answer is yes. There are certain things we will have to make sure the company can document. We talked about having enough the financial ability to pay the fair wage. Is a part-time or full-time. We have to show that the company has a very solid plan of action, a business plan showing that there is enough specialty occupation work available, showing that there is that employer-employee relationship, because these issues come up more often with startups, but absolutely startups can sponsor for H-1B.
And I'll just quickly address someone's question about whether you're in CPT, you've tried cycling through 2 more H-1B cycles, you're at the end of your program, perhaps just generally a master's, and your CPT is ending. Can you enroll in another master's degree program in CPT? It's at the discretion of the school, But if the school does allow you to enroll in a new master's program and work on CPT day one, it's generally not a problem, again, so long as the school approves. I will say, though, that you could potentially have a problem getting a new F1 visa abroad, because the consulates abroad are a little suspect with people studying for 1, 2, 3, 4 master's degree programs in a row and working on CPT. But if you're staying in the US, if it's just authorized by the school, you probably can.
The last question here is, does the person have to speak English to get an H-1B? The answer is no. That is not a requirement. I just want to point out that nowhere today did you hear that H-1B requires an employer to prove that there's no US worker out there to do the job. And the reason is because that's not a requirement for H-1B, except for one unusual circumstance, and that is if a company has far too many H-1B employees without a master's degree. Those situations could lead to a special requirement where a US employer needs to recruit US workers first and prove there aren't any available before they can hire another H-1B. But I've been doing this for 30 years, companies big and small. I've yet to have a company in that situation. So thank you all very much. We appreciate you listening. We hope you gained some takeaway tips for this. We hope it made things a little bit easier for you. And as we said, we're here for questions. Reach out, email any of us, and we're happy to get back to you. Hope you all have a great day, a safe day, and be well. Thanks.